Hello everyone. In the following two videos, we will be discussing the basics of patent law and compulsory license under the Indian Patent Act 1970. The term patent comes from the Latin word literi patens, meaning thereby an open letter. If we move to the historical background, it is found the concept of patent is not recent but has developed over a period of time. In year 1200s, 10-year monopoly was granted to the inventor of silk making device in Italy. First recorded patent was granted in England for glass making process. India had its first patent statute passed in the year 1856. Thereafter, there were several modifications and reenactments of Patent Act, ultimately resulting in the Patent Act 1970, which came into force on 20th April 1972. It has been amended many times after India became a member of WTO. Now, what is a patent? A patent is a statutory instrument of monopoly granted as a reward for an invention by the government to the inventor for a limited period of time, in return for which the inventor has to disclose to the public his invention in its entirety. A patent provides legal rights to you to exclude others from practicing your invention. It does not give the right to use your invention. Patent laws are national laws and there is no world patent concept. Now, the basic requirements for patenting your invention. Article 27 of the TRIPS lay down the basic requirements that has to be followed for all patenting your invention. It states that patent shall be available for any invention, whether products or process, in all fields of technology, provided they are novel, involve an inventive step, and are capable of industrial application. Patents must be available and patents' rights enjoyable without discrimination as to the place of invention, field of technology, and whether products are imported or locally produced. The patents and the pharmaceuticals. The most affected sector in India by the invention of the TRIPS agreement is the pharmaceutical sector. That is because the 1970 Patent Act has discriminatory provision for drug, food and agriculture sector, such as that is product patent was introduced in this sector. Now, there were various amendments were made to Indian Patent Act 1970 in 2005, and what the drastic changes that has been made by this particular amendment is that the validity for the patent, for any patent, is 20 years from the date of filing of the patent. Product patents will be granted for all inventions in all areas, whether for a product or process, provided they satisfy the basic requirements of novelty, inventiveness and industrial application. Life forms except microorganisms are not patentable. Under Doha Declaration, export of patented products were to be allowed to least developed countries with no capacity, provided they have compulsory license issued to them for the product. In case of infringements and litigation on process patents, burden of proof of non-infringement rests with the defendant. Compulsory license to be granted under specified conditions of national emergency or extreme national urgency. Now, in the second video, we will be dealing with the compulsory license, and you are expected to go with the quiz that is attached with this particular video. In this particular video, we will be dealing with the compulsory license. So, coming to the compulsory license, the first is, what is the meaning of compulsory license? Compulsory license means involuntary contracts between a willing buyer and an unwilling seller. imposed or enforced by the state. An extraordinary legal instrument whereby the state allows itself or third party to have access to, produce, use or sell the IP protected product or process without the consent of the IP owner. Mandatory and involuntary licenses as compelled by law. Patents in India are granted to encourage inventions and to secure that it is worked on a commercial scale. The Indian Patent Act ensures that a patentee should not be able to enjoy a monopoly for the importation of the patented article. When the patentees engage in unwarranted abuse of monopoly or dominance, by refusing to grant licenses despite the promise of adequate remuneration or impose unreasonable terms in patent licenses which restrict the use, sale or manufacturing of licensed product or charge monopoly prices which impinge upon the affordability of life-saving drugs or do not work the invention at all, then compulsory licenses can be issued to rectify the crippling effect of patent monopolies, more significantly in the case of life-saving drugs and essential medicines. The compulsory license, therefore, serves to strike a balance between two disparate objectives, rewarding patentees for their invention and making the patented products, particularly pharmaceutical products, available to large population in developing and underdeveloped countries at a cheaper and affordable price. TRIPS, Article 7 of the TRIPS provides for that protection and enforcement of intellectual property rights should contribute to the promotion of technological innovation. Article 8 of the TRIPS provides that in formulating or amending the domestic laws and regulations, members may adopt measures necessary to protect public health and nutrition. Article 31 provides that other uses without authorization of the right holder, where the law of a member allows for other use of the subject matter of a patent without the authorization of the right holder, including use by the government or third parties authorized by the government, the following provisions shall be respected. Article 31F of the TRIPS was the parallel, which mandates that any use without the consent of authorization of the patent owner shall be directed towards catering to the needs of domestic markets only. India, having a thriving generic pharmaceutical industry, can issue a compulsory license for manufacturing and sale of generic drugs at a lower cost, and thereby it can meet the domestic demand for replicated low-cost generic version of the patented drugs. Article 31F of the TRIPS agreement undermine the need for availability of medicines to the countries having less or no manufacturing capacity through importation from other countries. WTO adopted a mechanism to resolve this problem by implementing Para 6 of the Doha Declaration on the TRIPS Agreement in Public Health on August 30, 2003. Obligations under Article 31F of the TRIPS was thus waived off in case of export of pharmaceutical products to the countries having least or no manufacturing capacity, provided the eligible importing member has made a notification to the Council for the TRIPS. Section 84 of the Indian Patents Act deals with the grounds on which compulsory license can be issued, which are inherently broad and include reasonable requirement of public with respect to patented invention not being satisfied, non-availability of the patented invention to public at reasonably affordable price, the patented invention not being worked in India. Compulsory license may be applied by any person interested, but only when 3 years from the grant of patent had elapsed or expired. On 9th March 2012, India's first compulsory license was granted by the Patent Office to Natco Pharma Limited for producing generic version of Bayer Corporation's patented medicine Naxaver used in the treatment of liver and kidney cancer. The controller decided against Bayer on all the 3 grounds enlisted in the Patents Act for the grant of compulsory license. Aggrieved by the controller decision, Bayer immediately moved to the Intellectual Property Appellate Board, alleging that the grant of compulsory license was illegal and unsustainable. The board rejected Bayer's appeal, holding that if stay was granted, it would definitely jeopardize the interest of the public who need the drug at the later stage of the disease. It further held that the right of access to affordable medicine was as much a matter of right to dignity of the patients, and to grant stay at this juncture would really affect them. In concluding, I would like to say that compulsory license serves to strike balance between two disparate objectives, that is, rewarding patentees for their inventions and make the patented products, particularly pharmaceutical products, available to large population in developing and underdeveloped countries at a cheaper and affordable prices. Thank you, and this is followed by the quiz.